rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in Sembower versus Sembower, RCV number 210498FC. Counsel, we've read the briefs. We've conferenced this matter in conference this morning. Please, when you stand to the podium, because we are recording this, if you would announce who you are and which party you represent. And with that, the appellant may proceed.
Thank you, Your Honor. May it please the Court, my name is Stanley David Murray, and I'm the attorney for the appellant, Greg Sembower, who was the respondent in the lower court proceedings. I would like to reserve 5 minutes of my time for rebuttal, if I may. And, Your Honor, just a side note, that you're wearing masks. Did you want us to wear masks at the podium?
You don't have to.
Okay, I'm sorry. The relief that we're asking for in this appeal concerns reimbursement claim for debts that were assigned equally to each party. We're also asking for reduction in the attorney's fees award made by the trial court, and we're asking for attorney's fees on appeal. But the first part I'd like to address is the standard of review on the reimbursement issue. We filed a petition to enforce the debts that were listed in the decree. Enforcement issues involve interpretation of the decree. The court has to read what the decree provided and then enforce it as it's written. So we believe the standard of review would be the de novo standard rather than abuse of discretion, because the court misinterpreted the language in this decree that said each party had to pay 50% of the listed debts, as well as the unlisted debts, and then indemnify and hold harmless the other party from the debts that were paid. The language in the decree, again, is pretty clear, 50% to each party of those debts that were listed. If you look at the petition for enforcement, you'll see that that tracks exactly with the language in the decree. There's also provision about unlisted debts that to be also paid 50-50. And again, the petition tracks those as well. And then the indemnify and hold harmless is the basis for our claim for reimbursement. Now, there was some testimony, I have to admit, that my client admitted that he paid these debts voluntarily, and that the opposing counsel referred to it but didn't really get into the gift argument in the answering brief. But to address that, I would say that that's not relevant to this particular issue because of the Bobrow case that says since we're dealing with post-service, in this case post-decree debts that were paid, that a presumption of a gift does not apply. And even if those payments were made without legal obligation to do so, that standing alone doesn't impose a gift theory. So, yes, my client did make these payments, and in response to that question, I think he was answering in regards to the credit card that was in his name, but the wife was using. And so he paid that to clear his credit rating and to make sure that none of these debts got too far behind. And sure enough, he did ask the wife to pay these debts or to work on some of these debts to be paid. And the evidence at trial showed that she was going to file bankruptcy and otherwise was not going to make any payments. In fact, she testified that she didn't make any payments. So what was my client to do? He had to make these payments to preserve property, to preserve their credit history, and to take care of these debts to avoid adverse consequences. I think this case is even stronger for reimbursement than the Rudka and Bobrow cases that we cited because of the hold harmless agreement, or excuse me, not agreement, but hold harmless and indemnification language in this decree, specifying that for these debts that were paid, the other party was entitled to reimbursement, essentially, is what a hold harmless indemnification clause requires. So again, wife made no payments, indicated she wasn't going to do so. So my client, voluntarily, if you will, but again, because he needed to preserve assets.
You keep saying that she made no payments. Was there evidence in this record that she didn't make any payments?
Yes, sir. If you look at the cross-examination by trial counsel, she went through each debt, and Ms. Sembower responded, no, I did not pay that. No, I did not pay that. And she got cut off, basically, because of the time limits that are imposed in these trial court proceedings. But
Well,
she never testified she paid any of the debts.
Was it, I'm sorry, I thought that was as in, did you pay the debt as in the whole thing, not were you making monthly payments, et cetera, et cetera? Am I misreading that?
Oh, I thought if she had made any payments whatsoever, I don't know if it meant payment in full
Okay.
or partial payments. I wasn't there.
Well, counsel, wasn't some of the evidence that the payments weren't made because the properties hadn't sold because of your client's interference with the sale of the property?
Well, payment of the debts wasn't contingent upon the sale of the properties, though, Your Honor. That's not hand in hand. And
But
yes, if they had
the
sold,
court, if your client unreasonably withheld consent and did not cooperate, violated the court order and ultimately was held in contempt for that, is that enough to possibly result in a sanction of also then having to eat the debt that he paid?
no, because at the time, he had a viable claim to purchase that property himself, and he was trying to get Ms. Sembower to agree to allow him to purchase the property. So until that issue was
So
resolved...
he was strong-arming her.
No, he was exercising his rights under the decree.
Well, it sounds to me like he was strong-arming her. He was kind of blackmailing her, like, I know you can't pay off these debts, but I'm going to give you a lowball offer, so...
Well, actually, his offers matched the offers that she was receiving on both the Colorado property and the Scottsdale property. So, yeah, I dispute that he was in contempt, but of course we didn't win on that issue, so that's granted. But that happened after the fact when these negotiations were going on, when my client was trying to purchase the property. Would have resulted in more money for Ms. Sembower because she wouldn't have to pay the repair costs and the commission sales, et cetera.
So if you've got two provisions in the decree, one of them says cooperate, get the property sold, one says share the debts, and I use this one to delay getting the money that she could use, isn't that something the court could take into account and maybe say, hey, as a sanction, it's your fault you had to pay it, because if you'd have just gone through and followed the other portions of the decree, this would have went away?
Well, if the decree had specified that upon sale of the property, these debts would be paid off, I would agree with your the judge's analysis. But in this case, there were two separate issues. And so payment of the debts had to be made, and my client had the wherewithal to do it because he had access to his retirement fund at that time. So he took care of this for both parties' benefits, and regardless of whether the property sold or not, the debts got paid. So I suppose the trial court would have discretion in determining that this would be a sanction, but that's not what the trial court found in this case. So that would be speculative, I guess, on this record. Again, just summary, husband's reimbursement claim is based on the debts that were ordered in the decree. He's not paying debts that did not exist or that he created by himself. By finding that my client didn't have a claim for reimbursement, the trial court has essentially modified the decree. The language is clear that each party had to equally pay these debts, and now Ms. Sembower doesn't have to. She's been unjustly enriched, and the decree was modified in that regard without the compliance with Rule 85, Arizona Rules Family Law Procedure. The only way you can set aside a property division or a debt division is if you can meet the requirements of Rule 85, which were not alleged or presented by trial counsel for Ms. Sembower. And then on the attorney's, I thought I heard you say something. In regards to the attorney's fees that were ordered at the trial court, trial counsel made a rather ridiculous request for $78,000, and the trial judge did reduce it to $20,000. But unfortunately, it was for both the petition for contempt and for, I guess, prevailing, although I don't want to use that word, for the time that was incurred in opposing our petition to enforce the decree. We feel that Mr. Sembower was reasonable in opposing or in presenting his request for payment of the debts. And so the trial court should have considered that when making the award of attorney's fees. So the $20,000, although substantially reduced from the original request, concerns both issues when it should have been reduced.
Well, how would we know it? You say we should reduce it, but how would we know? That's a discretionary call with the trial judge.
That's true, Your Honor. There was no findings, none of the parties requested findings on the attorney's fees award. But because the language is so general, where Judge Blanchard said submit your application for attorney's fees, and the application included both the defense of the petition to enforce as well as the prosecution of the petition for contempt, I think it can be assumed that the judge awarded $20,000 for both claims when it should have been reduced for my client reasonableness on the...
So isn't the right outcome then, if we accept your argument, to just simply vacate and remand and let the trial court come up with its number?
Yes, sir, and especially because my client did not have access to any funds at that time. When the award was made, the retirement fund was restricted. My client had been retired. He didn't have sufficient funds to pay for his defense at that
How much
time.
is the retirement fund?
About $9 million, I believe, was the final distribution.
Yeah, I think the trial judge could consider that, right?
Well, that's the question I have. When you make attorney's fees award, you're supposed to consider the financial resources and reasonableness of the parties at that time, is my understanding. So
Did he have that $9 million retirement account at that time?
he had the account, but he didn't
Okay,
have
so
access.
he had a $9 million resource at that time.
That he couldn't access, yes, sir.
You could borrow against it. I mean, it's like saying I have a house, I'd have to sell it to access it, or I can access a resource in another way.
Well, no, the funds were frozen by Schwab, the holder of the account. He could not access or borrow against it until the quadro was finally entered.
Unt-
There's-
Okay, so the only holdup was signing a quadro. And it's not like this money is frozen because the United States government might take it from him. It's
No.
getting a quadro signed.
No, sir, the problem wasn't just the quadro, the problem was the marriage date. And opposing counsel filed an appeal on that. Actually, they filed a motion for reconsideration, and then we did an appeal, and then we finally got a decision that said, no, the marriage date is this date, and the quadro attorney was finally able to do the quadro.
Okay.
So, no, he did not have access. to
So he
the
doesn't have to pay the attorney's fees award until it was resolved. And once it was resolved, then he has access to $9 million.
Yes, sir, he does now. That's
Okay.
true. But again, consideration is reasonableness as well as the financial disparity.
Let me ask you this. If the trial judge has said, I'm giving you zero, I'm awarding zero attorney's fees on the petition to enforce, but I'm imposing $20,000 in attorney's fees for the contempt, do you have an issue?
I have no argument in that case, Your Honor, because then I would know that we were being denied attorney's fees. Of course, I'd probably raise it on appeal and say that was unreasonable or abuse of discretion.
It would be the reasonableness of the $20,000, not that,
Yes, sir.
okay.
And then we're asking for attorney's fees on appeal, again, on the reasonableness issue in regards to the reimbursement claim.
But you're just told us that he has access to $9 million. So in the equation of the reasonableness of the positions on appeal, we also factor into the fact that your client has access to $9 million in finance.
Yes, the financial disparity, I would concede, but again, it's a two-part analysis, not just on the financial issue. So we'd ask the court to consider the reasonableness. Unless the court has any other questions, I'm going to reserve my time for rebuttal. Thank
All
you.
right, thank you. Good morning.
Good morning, Your Honors. My name is Patricia Mellon. I am here representing Larissa Falcon, who is the petitioner and appellee in this matter, and she's here with us today. I wanted to focus on three issues that I believe contribute to the analysis of this matter. And I have the same reaction as my esteemed opponent here to talk about the standard of review. The parties obviously differed in their briefs on the standard of review. And I still believe that the abuse of discretion is the correct standard of a review to apply to this matter.
Aren't we interpreting, not to interrupt, but aren't we interpreting the decree?
Your Honor, I don't believe so. The lower court treated this in the way that it was framed as a petition for enforcement
Of the decree.
of the decree.
So you start with the decree.
Correct.
And the decree said we're apportioning the debt
50-50.
50-50, and you're going to hold harmless for the other spouse if you fail to pay your, not you personally, I know that.
Understood.
If your client fails to pay, she is going to hold harmless the other party. That's what the decree says.
Yes, Your Honor.
So if she failed to pay, he could sue her under the decree.
Your Honor, he actually...
Yes or no?
Yeah, yes.
So why are we here?
Your Honor, we're here because the trial court, in its discretion, in the request to enforce, didn't find that she had not paid. She hadn't paid yet. And I believe Your Honor's discerned correctly that in a high conflict divorce, matters are intertwined. And so, yes, Ms. Falcon could not pay. And that is one of the issues in how this particular motion that led to the order that we are here to talk about, the way it was postured as a motion to, or a petition to enforce. That is specific language related to a contempt action. And contempt in Arizona, much like Colorado, requires an ability to pay. And Ms. Falcon had no ability to pay. At that time, she discussed, there were many things being discussed in negotiations regarding extreme positions.
Well, hold on. If he filed this petition to enforce, did he ask for a lump sum payment?
Yes, Your Honor.
And the trial judge had the discretion to say, she doesn't have the ability to make a lump sum payment, so I'm going to order her to pay $100 a month until it's paid in full.
If he believed that that was the correct outcome, he could have ordered that. He did not.
How is that, isn't the answer, he could have done that and been consistent with the decree?
He could have done that. However, I believe that would be taking one particular item of this divorce decree out of context.
What is that?
This particular, the resolution of these debts can't be separated from the resolution of the sale of the properties.
Does it say that in the decree? I didn't read that in the decree.
It doesn't say that in the decree. But in terms of enforcement of particular positions, interpretation of the decree, if you want to go in that direction, requires that it be interpreted in its plain language in the context of every other term.
Okay, well, let's go with that. So he could have said that he, being the trial judge, could have said, you are right, she now has to reimburse him and will do that upon the sale of the property.
He could have said that. He did not.
But where does it give him the authority under the decree to simply abrogate the debt as it related to your client?
Your Honor, what the court found was that the
Okay, you're not going. It sounds like you're not going with my
Okay.
answer to my question.
Okay, so-
Where in the decree does it say he has that authority?
It does not say it in the decree expressly. The trial court hears the evidence and assesses the credibility of each witness it sees at trial. In this particular hearing, which I listened to, it was when I had first joined the case, this court, after assessing the credibility of the witnesses and the information that was provided, found that Ms. Falcon had not complied. I realize that's a double negative, but that was really the standard. Mr. Sembower alleged that she had not complied with the decree. At that time, her answer was, I intend to, I'm not able, I'm prevented from doing this by your actions, and therefore, what you did to resolve this is outside the judicial process.
So let me ask you this. Let's assume that the trial court could have sanctioned the husband
Right.
and ordered this as a sanction, but that's not what the trial court did. Because it seems to me that's what you're arguing. This is a sanction. But I don't see that you were anywhere where you've argued that this is an appropriate sanction. So I don't know how that's before us.
Well, Your Honor, my understanding of Arizona law is that Mr. Sembower had a perfectly viable alternative method of resolving what he called his concerns about his credit rating and the interest. Under Arizona statute 25-318, there's an entire process for what is not a new problem in high conflict divorce. How do you enforce the division of debts when one of the parties seems unwilling to participate? So he had an alternative that he chose not to use, and he robbed Ms. Falcon of her ability to, A, understand the debt from the creditors themselves, make any effort to reduce the debt so that she would have less liability, they both would have less liability, or she would have less liability.
But where does it say in the decree he has to put his own credit at risk to let her do that? Because that's what it would take, right?
I believe not, Your Honor. I believe that this...
So it wouldn't affect his credit at all if these debts remain still today unpaid?
That was not... So in terms of enforcement prospectively, that's what this statute intends to address, is that it provides an opportunity for a reluctant or low resources spouse to put a payment plan together that is enforceable. And so the drastic nature of his actions robbed her of the ability to create a payment plan at a time when she had no access to her employment. She had been barred from the party's residence. She was a home-based business managing their rental properties and a horse ranch. She was essentially destitute, starting over, without a $9 million 401k that was fought over for 2 years. So what the trial judge recognized was that this was in fact a strong arm action, that this particular aspect, he knew that she did not have the means to pay it in a lump sum. She didn't have the information available to even know what the debts were at the time. He didn't provide her an opportunity to agree to his plan. He didn't provide her an opportunity to create her own plan. She had a child and housing, a child to support and housing to procure with no income and no access to the party's liquid assets. And that is one thing, a second topic in terms of going back to standards of review. The reason why we believe that the standard of review should be discretion is that this is was postured more as a contempt or enforcement action than an interpretation. One of the requirements...
So, you keep saying that, but this is an enforcement of a decree, which means that we look at the decree and what authority the court has within the decree.
Understood, Your Honor, but my question... And
the court can't modify the decree, right?
Correct. The person requesting to modify the decree was the appellant.
Oh, no, he was... Please hold me harmless because I paid the debt.
Well, the problem is that when you're doing an interpretation argument and you want to avail yourself of the de novo standard, you have to prove that something in that decree was ambiguous. That's not been an argument either at the trial court or in this appeal. There's nothing in the briefing here or in the trial court that talked about what aspect of that decree was considered ambiguous or subject to two different interpretations.
Oh, I'm not sure I agree with you there. If I read the decree and it says what it says and the trial court does something completely different, I don't have to have an ambiguous statement in the decree. I just simply say, no, the trial court had no legal authority to do what he or she did.
Okay. I believe, Your Honor, that the point here is the difference is taking the difference in the parties' resources and the difference in the parties' actions were what the trial court had to consider in this matter. And that trying to take this one item of the debts out of context would have been prejudicial to Ms. Falcon. There were deficiencies in this decree that caused additional issues for the parties that were exacerbated by the differences in their resources. The biggest single issue is of silence under Jurowski is that the decree does not mention at all the management of the home-based businesses and Ms. Falcon's ability to financially provide for herself in the days immediately following the filing of the paperwork. So there's nothing in the decree regarding liquid assets, bank accounts, savings accounts, any immediate availability to funds to pay her own expenses, let alone to pay for these large debts that were accumulated during a much different financial situation during the marriage.
Counsel,
Yes.
Didn't the Superior Court find that husband paid the debts at his own peril,
Yes, Your Honor.
and that it was a voluntary payment,
Yes,
and
Your Honor.
therefore treated them as a gift?
Well, the word gift does not appear in the order.
So what did it treat them as? Because I'm not trying to understand what those payments were. If they were, just to say that they were voluntarily and at his own peril, when the decree says, and if you pay them, the other spouse will hold you harmless.
Your Honor, I believe that the timing of this makes a difference. There's a fair amount of case law regarding gifts between spouses pre-decree. This is a situation where, without an pre-agreement and without even notice, Mr. Sembower, who is no longer related to Ms. Falcon, paid debts that were not his responsibility.
And we said in Beaubrow that we have to look at the donee's intent.
Correct.
Is there anything in this record that would support that he was doing this just to give her a gift?
Well, there's evidence in the record that he did it in part to benefit her. In the transcript in his testimony, he was saying he did it to benefit her, to benefit both of them, and to benefit himself. The question becomes what credibility you apply to those statements.
But the fact that he may have motives or reason, I mean, that's what they argued in Beaubrow as well, but that we still look at the intent.
Right.
Did he intend to give her a gift, as in, I don't expect you to repay me?
There was no communication between the parties, period,
So
regarding
the
this.
answer was no. There was nothing in the record that would indicate that his intent was to abrogate the debt for her.
The intent, no, Your Honor, I'll answer that directly. There was nothing said in the record based on the testimony provided that his intent was to give her a gift. What is in the record throughout this case, beyond these pleadings and the testimony, is his intent to deprive her of access to funds. And so to be able to wipe out her equity and her share of the equity in the properties cannot be avoided in an analysis of why he did this.
So let me ask you this, counsel, because you've said it. You said that these were debts that were not his obligation, correct?
Portion of these debts are not his obligation.
And isn't that an inaccurate statement in that while the court in a dissolution in equity can allocate the debt between the parties, that has no impact on those third-party creditors who can hold one or both liable. In other words, they could sue just Mr. Sembower, they could sue just Ms. Sembower, or they could sue them both to seek recovery. The court has no power to affect that third-party creditor right.
Understood, Your Honor, yes.
So weren't they debts that were actually still his? Just the decree allocated them between the parties, but it's a misstatement to say that they were not still his debts.
Well, Your Honor, the question becomes some of those debts were in Ms. Falcon's name. So it wasn't, he's asking for not only the debts that were true in the decree, he's asking for payments that were made for his own maintenance of his own location, right?
That's a separate debt that we're talking about. I'm just talking about the community debts that were allocated between the parties 50-50 that he paid.
Your Honor, I agree with you that according to Arizona law, the debts remain to the person who actually engaged the creditor, not The question becomes, under the statute, can that be modified, and can payment agreements be made with the actual creditors that are different than a lump sum payment when it wasn't due? So it's all a matter of how you interpret the decree about timing. Mr. Sembower admitted in testimony that the debts were not due. He simply chose to do it because he wanted to do it.
But that seems to me that in that situation, a remand is appropriate to tell the trial judge, look, it's still her debt. Whether or not it's her debt to a third-party creditor or her debt to him, you have to determine what is the obligation on repayment.
Well, but Your Honor, the question becomes, the trial court heard evidence about his intent and in context of the rest of the divorce proceeding. This divorce has gone on for now 2.5 years. And this was one slice of that interaction and court measures. You've seen the record on this case. It is enormous. And so the trial court, after hearing the evidence and hearing the testimony, seeing the actual presentation of statements, didn't find that it was credible that he did this for any other reason than to withhold funds from her, and that he had options.
He had options, but there was nothing in the decree that required him to exercise it one way or the other, correct?
Well, the decree did not, you're correct. The
Okay,
decree
and then I have
did,
another question. Is there a single case in Arizona that suggests or says that one spouse can't prepay the community debt? I have not found one. So have you found one?
I have not, Your Honor.
So you're asking us to make a rather remarkable holding. What case is consistent with that? How do you line that up and square it with our other law?
Your Honor, cases of first impression happen, unfortunately. The cases that support this are the ones under enforcement, and that he did not meet his burden of proof, that she had not paid the debts, that she still intended to pay the debts. The threat of bankruptcy was simply a threat. If that in fact happened,
She could do that now
she could do that now.
and discharge all of the debts to him.
And she hasn't, and she won't. But the law is not intended to be prospective, and the enforcement is not
Do you
intended to
really
be
think we should
prospective.
get into the evil intent? Let's say that he didn't do this for nefarious reasons. He just didn't he didn't think that she could pay the debt. And so he instantly paid all of the bills, all of them, all of the community debt. And then a year later, he says, oh, by the way, you need to pay me these back. She says, I'm not paying them back to you. And he files a petition to enforce.
Your Honor,
Do we look at the evil motive of why the person paid off the debt?
I think the motive matters, Your Honor, and the timing was slightly different. The decree came out in February. By September, the payments had already been made, and the petition was already before the court for the reimbursement. So this was a short period of time.
All right, thank you. Your time has
thank you.
expired. Mr. Murray.
Thank you, Your Honor. Stan Murray again for the appellant. Just a couple of points I'd like to address on the ability to pay issue. Remember, this decree was an equal division of both property and debts. So as far as Ms. Sembower not being able to pay these debts, the court would have considered that in entering this decree. So Ms. Sembower was awarded 50% interest in the 2 real estate properties, and those funds could have been used to pay off this debt, not immediately. We weren't asking for an immediate lump sum payment. We're asking for a lien against the proceeds once the sale did occur. So as far as my client strong-arming the situation, he was willing to wait for the payment once the property sold, either to him or to a third party. So this
Counsel,
argument, sorry?
you mentioned that the court, in issuing the decree, the court would have considered her ability to pay. Where in the record does it indicate that it did consider her ability to pay?
Well, I'm assuming that based on the equitable division of property and debts. If my client was the one that had all the assets and had all the community property, then I'm sure the court would have said, you pay all the debts as a result. But because the trial court made an equitable division of these assets and debts, Ms. Sembower had the ability to pay, or else the court wouldn't have said, you pay 50% of all this community debt. Is what our position would be on that. And remember, this is a short-term marriage. This is only about 3 years. So there isn't much community property that's been acquired. So the community property should have been used to pay off these debts. My client went ahead and paid it with his separate funds, and he's asking for reimbursement from the sale of community property that Ms. Sembower was entitled to, and that the trial court probably considered in determining that she would have to pay 50% of the debt. On the gift issue, the voluntary payments, again, Bobrow says even if it's voluntary, if there's no legal obligation, you're still entitled to reimbursement. And the burden of proof is on the opposing party, the party that's claiming that it is a gift, to prove by clear and convincing evidence that a gift was intended. And so under Bobrow, we look at the donor's intent. I could tell you, based on the history in this
Actually,
case.
what Bobrow says is that trial court is supposed to consider that in making an equitable division.
Whether a gift occurred?
On one, you don't make it as it's not a gift, but you're supposed to can take into consideration the payments made on community assets and reimbursement when separate funds in making an equitable distribution. It doesn't say a straight up reimbursement.
No,
it says an equitable distribution.
That's correct. But we're at the enforcement stage now rather than the distribution stage. So when it comes to enforcement, if one party pays off all these debts, despite whether or not a legal obligation exists, they are entitled to reimbursement. That's the only fair and equitable way to handle it because they were ordered to pay 50% of the debts. Those are the 2 points I wanted to cover, unless the court has any questions. Thank you.
All right,
members.
thank you, Ms. Murray. Matters deemed submitted will issue a decision in due course.